I understand the lecturers are being introduced before they start the lecture. I don't want to be introduced. I'll just introduce myself. I am Judge Maria Cristina CORNEJO, Regional Trial Court, Makati, the Republic of Makati, Branch 147, the B9 country. Okay. So I'm sorry, but I have to give notice as early as now that I will be dismissing early because I'm not really, truly, honestly, I am truly, honestly sick. But I'll try to cover as much. Don't worry, I'll finish tomorrow the coverage because I'm assigned criminal procedure now. Ang dami niyo. Can you see me over there? I'm kind of short, you know. Can you see me over there? Sagot. Okay, a very important concept in criminal procedure as well as in civil procedure is of course jurisdiction. Please do not forget that it's very, very important, the concept of jurisdiction. You know very well that jurisdiction refers to the authority. Authority of the court to hear and decide a case. This is likewise how it is defined in civil procedure. It refers to the authority of the court to hear and decide a case. Now, as far as criminal cases are concerned, when you talk about jurisdiction, you are likewise talking about in the event of a judgment of conviction being rendered, there is an imposition of penalty by the court, correct? Now, the imposition of the penalty is referred to, in cases of judgment of conviction in criminal cases, that is referred to as the exercise of jurisdiction. But as far as jurisdiction is concerned, you're actually referring to authority of the court to hear and decide a case. Now, very important to remember, please, that I think this is likewise the same as in civil procedure. Jurisdiction is determined by the law in force at the time of the commencement of the action. Okay? So jurisdiction is determined by the law in force at the time of the commencement of the action. As far as criminal cases are concerned, the criminal action, you talk about commencement of a criminal action, di ba, for purposes of prosecution, for purposes of initiating and determining probable cause in cases of absence of any arrest situation, you file your complaint before the prosecutor's office. You file a complaint before the prosecutor's office for purposes of a PI, a preliminary investigation. That is commencement of a criminal action. Now, when you say commencement of a judicial action, of a judicial proceeding, when is the judicial proceeding being commenced? It is at the time of the filing of the information in court, which is the formal indictment, the formal charge as against the accused. Okay. Now, when you say jurisdiction is determined by the law in force at the time of the commencement of the action, therefore, if you're in a quandary as to what court would have jurisdiction over this particular case, a criminal case, then you have to determine what is the operative law at the time you are filing the complaint. So what is the law? Because there is a law that confers jurisdiction on each and every court. There is a law that says what court has jurisdiction over this particular case. Same concept as far as civil procedure is concerned. Now, there are actually two laws. You know this, no? There are actually two laws that confer jurisdiction on the courts. One is BP 129, right? Okay, BP 129, which is the Judiciary Reorganization Act of 1980. And then it was amended by Republic Act 7691, which expanded the jurisdiction of the MPCs. So the Republic Act 7691, which expanded the jurisdiction of the MPCs, was promulgated as early as April of 1994. Remember? It was promulgated as early as 1994. BP 129, however, is promulgated as of 1980 because it is a Judiciary Reorganization Act of 1980. Okay, so your principle that jurisdiction is determined by the law in force at the time of the commencement of the action, you have to be aware of the two laws that confers jurisdiction. Therefore, if let's say a at the time of the commencement of the action, at the time of the filing of the complaint, before the prosecutor's office, for purposes of a preliminary, even for purposes of a preliminary investigation, the operative law is BP 129. What is the jurisdiction of the NTCs as far as BP 129 is concerned in criminal cases? If the imposable penalty or the penalty prescribed by the code for the offense charged is imprisonment of up to prison correctional medium. Diba? 4 years, 2 months under BP 129. But upon expansion of the jurisdiction of the NTCs by virtue of the promulgation of 7691, the jurisdiction of the NTCs now will be up to the full extent of prison correctional, which is 6 years. Pagka 6 years and 1 day, RTC na yan. Kasi yung 1 day. Because it is already prison mayor. So you have to be very conscious. Now, if the jurisdiction, if the operative law at the time the final commencement of the action is BP 129, you take note of the penalty in order for you to know what court has jurisdiction. Because you're now going to refer to that law, which is operative at the time of the commencement of the action. Guess nyo? Okay. May sakot pa ako niya. Mamaya pag nakatulog ako, bukas malakas na. Okay, now, next point to remember, please. Take note, this is likewise applied in civil procedure, the doctrine of adherence of jurisdiction. What do you mean by doctrine of adherence of jurisdiction? Once the court acquires jurisdiction over a particular case, as conferred upon it by law, that jurisdiction remains with that court, irrespective of subsequent developments, irrespective of subsequent amendatory laws. Except if the amendatory law provides for a retroactive application. That is the rule. Doctrine of adherence of jurisdiction. This doctrine likewise applies in civil cases. You took this up in your CIVPRO. Okay, now, how do we illustrate this? Which means that, sabi natin, i-relate natin two rules. Jurisdiction is determined by the law in force at the time of the commencement of the action. If the law in force at the time of the commencement of the action is BP 129, and the offense is penalized with a penalty of, let's say, prison mayor. It is penalized with the penalty of prison mayor. Let's say, it is penalized with the penalty of prison correctional maximum. Ayan na. Prison correctional maximum. At the time of the commencement of the action, at the time of the filing of the complaint, the operative law was BP 129. And the accused is charged with an offense for which the code provides a penalty of imprisonment of prison correctional maximum. Question, what court is jurisdiction? RTC, di ba sabi sa nila, up to 4 years and up to prison correctional medium, which is 4 years and 2 months. So 4 years, 2 months and 1 day, under BP 129, ano na yan? RTC. Okay. So at the time of the commencement of the action, operative law, BP 129, the penalty imposed is imprisonment of prison correctional maximum. So final sa RTC. During the pendency of the action, before the RTC, pasok Republic Act 7691, which expanded the jurisdiction of the MPCs. Question. Upon the expansion, upon the promulgation of 7691, which expanded the jurisdiction of the MPCs, during the pendency of the action before the RTC, is the RTC effectively deprived of jurisdiction over that case? What do you think? Is the RTC effectively deprived of jurisdiction? Kasi na-expand na eh. Which means that, by virtue up to 6 years. Kasi impossible that is prison correctional maximum. Is it RTC effectively deprived? No! Doctrine nga of adherence of jurisdiction. Adhere, stick, kabit. Diba? It sticks. What jurisdiction? Once the court acquires jurisdiction over a particular case that's conferred upon it by law, that jurisdiction will remain with that court until after the termination of the case, irrespective of subsequent developments, irrespective of subsequent amendatory laws, except when the amendatory law provides for a retroactive application. Sige? Yes. Okay. Next point. This is likewise the same as civil procedure. Yung di ba, jurisdiction is always conferred by law. Now, as far as, lalo na if it's criminal case, you know very well, no? Yung venue as distinguished from jurisdiction. Di ba, there are points of distinction as far as civil cases are concerned. Venue, of course, is same concept naman. It is the place of institution of the action. But whereas in civil cases, venue can be agreed upon. In criminal cases, no. Because venue in criminal cases is jurisdictional. That's another point to remember as far as criminal cases are concerned. Okay, now we talk about jurisdiction. What would be the jurisdiction or the extent of the jurisdiction of the MTCs? Oh, you know, no? If the penalty, as provided for now under 7691, is up to prison correctional to its full extent. Prison up to 6 years. If it is more than 6 years, RTC na. Likewise, MTCs have jurisdiction over violations of city and municipal ordinances, violations of the traffic laws. Dati importante sa akin yan. Violations of city municipal ordinances, violations of traffic laws. Okay, now, criminal negligence. Criminal negligence under 365 of the revised penal code offenses, they fall under the jurisdiction of the MTCs. Question, do the MTCs have jurisdiction over offenses committed by public officers or employees? Do the MTCs have jurisdiction over offenses committed by public officers or employees? Yes. Yes. Now the MTCs have jurisdiction. Okay. The MTCs have jurisdiction with respect to offenses committed by public officers occupying salary grade below 27. Kasi pala, yung jurisdiction is conferred by law. It is conferred by the law that is operative at the time of the commencement of the action, except if jurisdiction would depend on the position occupied by the accused at the time of the commission of the offense. So, kapasok pa rin yan. Now, once you go to the RTC, what is the extent of the jurisdiction of the RTC? You know this, if the imprisonment exceeds 6 years. Which is prison mayor. 6 years and 1 day, prison mayor, that is already falling under the jurisdiction of the RTC. Next, what about offenses likewise committed by public officers employing occupying salary grade below 27, meron pa rin sila jurisdiction, depending on the case, the nature of the case. Now, next, what about the family courts? Please remember, in the organizational setup, by virtue of Republic Act 8369, that is the law that creates the family courts. But sadly, for lack of funding, our family courts are not actually created separately from the RTCs. Presently, there are family courts, but they are only designated. They are basically and essentially regional trial courts. Magiging special courts lang sila. And they are given jurisdiction as conferred by law, Republic Act 8369 on family courts. So they are designated as family courts. Now, what would be the extent under the Republic Act 8369? What would be the extent of the jurisdiction of the family courts? Now, family courts, they have jurisdiction, exclusive jurisdiction over offenses, over criminal cases where any of the accused or any of the private defendant parties is a minor at the time of the commission of the offense. Take note of this, where any of the accused or any of the private defendant parties is a minor at the time of the commission of the offense. You have to be careful with this, because one time it happened sa totoong buhay. It's a regular court, the case was filed before the regular court, and a witness was called to the witness stand to testify for the prosecution. The witness was a minor. Sabi ng judge, I have no jurisdiction. This belongs, the witness is a minor. This belongs to the family court. Hindi witness, complainant, any of the complainants, any of the private defendant parties, or any of the accused. Not a mere witness. that could place the case under the jurisdiction of the family courts. Okay. What else? Family courts have jurisdiction over violations of the DDL, the Dangerous Drugs Law, committed by minors. Violations of the DDL, Dangerous Drugs Law 9165, as committed by minors. Family courts have jurisdiction over violations of 7610, the Child Abuse Law. Family courts likewise have jurisdiction over cases of domestic violence against women and children, 9262. Okay, family courts have jurisdiction. They apply now the correlative laws with respect to the jurisdiction. Okay, now, what about Sandigan Bayan? Please take note that Sandigan Bayan has both original and appellate jurisdiction. Sandigan Bayan has both original and appellate jurisdiction. In criminal cases, the Court of Appeals only has appellate jurisdiction. In criminal cases, the Supreme Court only has appellate jurisdiction. But the Sandigan Bayan has both original and appellate jurisdiction. Okay. I think it's part of the coverage, yung distinction, yung Republic Act 7975 in relation to Republic Act 8249. Both are Sandigan Bayan laws that provide for the jurisdiction of the Sandigan Bayan. Yung 7975 has been amended by Republic Act 8249. So, una dyan, 7975. Next, amended by Republic Act 8249. Now, if you analyze where lies the difference between these laws, sabi dun sa 7975, the Sandigan Bayan has exclusive original jurisdiction over violations of 3019 Anti-Graft and Corrupt Practices Act, where one or more of the principal accused, are officials occupying salary grade 27 or higher. Tingnan niyo dyan 7975. Violations of 3019 where one or more of the principal accused are public officials occupying salary grade 27 or higher. Tingnan niyo dun sa 8249. This is where there is an amendment. Violations. Sandigan Bayan has original exclusive jurisdiction over violations of 3019 where one or more of the accused are public officials occupying salary grade 27 or higher. Saan yan ang difference therefore? In 7975, kinwalify one or more of the principal accused are public officials occupying salary grade 27 or higher. Republic Act 8249, where one violation of 3019, where one or more of the accused, wala nang principal accused, one or more of the accused are public officials occupying salary grade 27 or higher. So pag sinabi mo one or more of the accused, that would include accomplices, accessories, correct? Pero to sa 7975, one or more of the principal lang, principal accused. Now, sa 8249, inclusive na. Any one or more of the accused. Gets ya? Okay, now, next point of distinction, 7975. Sandigan Bayan has original exclusive jurisdiction over other offenses or felonies committed by public officials occupying salary grade 27 or higher in relation to their office. Diba? Ito yung qualifying phrase. Occupying any other offense other than violation of 3019. Public violation or other offenses committed by public officers or employees occupying salary grade 27 or higher, and they are committed in relation to their office. Let's go muna to 8249. Same. Or sandigan bayan has original exclusive jurisdiction over other offenses or felonies, whether simple or complex. Sa 8249 yan, pinwangpan. Other offenses committed by whether simple or complex, with other crimes committed by public officers or employees occupying salary grade 27 or higher in relation to their office. So sa second difference nila, pareho na in relation to their office. Now, the Supreme Court has said, you have to qualify. What do you mean by in relation to their office? Meaning that, sorry, the office must be a component part of the crime. It must be an essential part of the crime. It must be a component part of the crime. For example, di ba yung motor station? It must be, the offender here must be an accountable public officer. So, pag sinabi mong in relation, the offense cannot be committed without taking consideration of the position occupied by the accused. In other words, according to the Supreme Court, in one case, which was promulgated in 2001, the Supreme Court, it is the nature of the offense and the position occupied by the accused at the time of the commission of the offense. Again, the nature of the offense and the position occupied by the accused at the time of the commission of the offense. These are the conditions sine qua non before the Sandigan Bayan can take cognizance of a case. Again, the nature of the offense and the position occupied by the accused at the time of the commission of the offense, these are the two conditions sine qua non, indispensable, before the Sandigan Bayan can take cognizance of a particular case. Okay, now, I said Sandigan Bayan has original jurisdiction as well as appellate jurisdiction. Appellate jurisdiction over what? Over decisions of the RTC. Whether RTC exercises its original jurisdiction or exercising appellate jurisdiction over decisions of the MTC. So, Sandigan Bayan has both original and appellate jurisdiction. Yung appellate niya over decisions of the RTC which have been rendered by the RTC either in the exercise of its original jurisdiction or in the exercise of its appellate jurisdiction over decisions rendered by the MTC. Okay. Now, I mentioned earlier, that as far as the Court of Appeals are concerned, as well as the Supreme Court, they have purely appellate jurisdiction in criminal cases. We'll take yung appellate nila. We'll take it up later when we get to appeal. Okay. Now, let's go to the rules proper. Very important, please. May amendment. I'm pointing out the important amendments. Now, Rule 110 starts with Rule 110. If you notice, prosecution of offenses. Kasi in Rule 111, it is prosecution of civil action. Okay. Prosecution of offenses under Rule 110, Section 1, there's already an amendment. Remember, this is, we're dealing with the revised rules, 2000 rules, as amended, criminal procedure. Okay. Section 1 is very important because, sorry, the criminal actions shall be instituted. This is institution of criminal actions. Please take note, institution of criminal actions for purposes of PI. Preliminary investigation. Okay, sorry. For offenses where a PI is required pursuant to Section 112 by filing the complaint with the proper officer for the purpose of conducting the requisite PI. Okay, first question, first point. When is a preliminary investigation required? Before the revision of the rules, take note. If the case is cognizable by the MTC, preliminary investigation is not a matter of right. When I say matter of right, it can be demanded by the accused. Before the revision of the rules in December of 2000, But if the case is cognizable by the NTC, preliminary investigation is not a matter of right on the part of the accused. Unless you can come up with a very, very good reason, compelling reason, the NTC will not grant it. So, when is a preliminary investigation under the present rules a matter of right, meaning it is required that you go through, even if it is cognizable by the MTC, for as long as the imposable penalty is at least 4 years, 2 months, 1 day. Less than 4 years, 2 months, 1 day, PI is not a matter of right. But if it is, if the imposable penalty is at least 4 years, 2 months, 1 day, preliminary investigation is required, it is mandatory, and therefore it is a matter of right on the part of the accused. Therefore, tingnan niyo, before the revision of the rules, I told you, PI is not a matter of right in cases cognizable by the FTC, putting direct firing, even without a PI, under the present rules. Even if FTC case, for as long as the penalty imposed is 4 years, 2 months, and 1 day, PI is a matter of right. PI is required. Jurisdiction of FTC stands up to 6 years. So PI now may be compulsory. PI may be a matter of right, even in cases before the FTC, for as long as the imposable penalty for the offense charge is at least 4 years, 2 months, 1 day. Next, ito ang paragraph B of Section 1 of Rule 110, erase na yan. Because effective October 3, 2005, FTC judges are no longer allowed to conduct PI. As of October 3, 2005, only the prosecutors, the fiscals, can conduct PI now. Talagang delineated na. So, PI now is already talagang strictly an executive function. Di ba pag executive? Executive, yung fiscals, they are under what? They are under the Gonzales. Di ba? Gonzales is the DOJ. And the DOJ is under the GMA. Office of the President. So, executive yan. The prosecutors now are only the ones authorized before the revision of the law, before this particular admin order of the Supreme Court promulgated and effective October 3, 2005. Di ba FTCs can conduct PI? Subject to review by the provincial prosecutor. Okay, so now it's FTC judges. That is why in that particular circular or administrative order, FTC judges would have to terminate all PIs that they were conducting preliminary examination, preliminary investigation as of December of 2005. So presently, wala na. They're really no longer authorized. They can no longer conduct PI. FTC judges. Okay. Very important is the third paragraph. The last paragraph of Section 1, Rule 110. Sabi dito, this would refer to the prescription. The institution of the criminal action shall interrupt the run of the period of prescription of the offense charge unless otherwise provided in special laws. 1. The institution of a criminal action for purposes of preliminary investigation. The filing before the fiscal's office, that is the institution of the criminal action, commencing the criminal action for purposes of a PI. It already interrupts the period of prescription of the crime. Unless, sabi nito, there is a special law, unless otherwise provided in special laws. Remember, this particular short paragraph actually already incorporates the doctrines laid down in the case of Luzon Divya, versus Honorable Andres Reyes, it's San Mateo case. And that is 1996, and Rio Dica, 1992 or 1996. Rio Dica versus CA, that's a 1998 case. The doctrines laid down in these two cases are now incorporated in this particular paragraph of the rules. The institution of the criminal action shall stop the running of the period of prescription. Have you read the Saldivia case? Yung Saldivia case, 1992 pala. 1992, where she was indicted and she stood trial for violation of a municipal ordinance. She was convicted by the MTC. She appealed She appealed because her contention was, at the time of the file, I cannot be convicted because at the time the file the information prescribed na. Even if it is filed, even if it was, what do you call this? Even if it was filed before the fiscal's office, at the time the file of the information in court, it has already prescribed. Because it is a life offense, it's a violation of a municipal ordinance. Okay? So, the decision of the FTC, the RTC, the CA reversed. Why? Listen to this, because it happened that there is such a law, 3326, which provides for violations, making provisions for violations of all city and municipal ordinances. And that particular law provides for the prescriptive period of any violation of city or municipal ordinance. What is provided for there? The provision there with respect to the period of prescription of the violation. Di ba offense na yun? Violation of city or municipal ordinance? Okay, so that is an offense. Now, what is the prescriptive period? Sabi, the prescriptive period shall be interrupted upon institution of judicial proceedings. Very clear. Nakalagay na, the period of prescription of any violation of city or municipal ordinance shall be interrupted upon the institution of judicial proceedings. As I said earlier, when are judicial proceedings deemed instituted? Upon the filing of the information in court. Correct? Upon the filing of the information in court. So, even if it is filed before the fiscal's office, the violation of the city or municipal ordinance, it did not stop the running of the period of prescription. What will stop the running of the period of prescription of the offense of violation of city or municipal ordinance is the filing of the information in court. And what is the basis for that? That law, 3326. Now, therefore, sabi ng Supreme Court, it is now amended. Once a complaint is filed before the fiscal's office or the prosecutor's office, even for purposes of a preliminary investigation, the general rule is interrupted na kagad ang period of prescription of the crime charge. Except when there is a special law that provides for its own period of prescription of the offense and that provides for its own interruption of the period of prescription of the offense. Paano? That is the rule now. Filing to the fiscal's office, interrupted. But if there is a law that provides for its own period, yun na susundin. No, you follow that law. Special law. See clear? That is the present rule now. Okay, now, I need not discuss, of course, itong complaint or information, you know this, no? Complaint defined. Okay, let us just go to what are the offenses that cannot be prosecuted de officio. Of course, you know, what is the concept of an offense or a crime that cannot be prosecuted de officio? Meaning, it cannot be prosecuted. These are certain crimes that cannot be prosecuted except on complaint filed by the offended party or by, if it's a minor, by the parents, the godparents, or the guardian. You know? Those are the crimes. All other crimes which can be prosecuted de officio, it can be filed by anybody and then information can be filed by the fiscal. Okay, now, may amendment dito what are the crimes that cannot be prosecuted?
Ano yung pinakalas na yun?
Okay, so it's not, these are the crimes that cannot be prosecuted the official, repeats priorities. These are the crimes that cannot be prosecuted the official now, under existing laws. Kasada. Concubinage, adultery, seduction, abduction, defamation, consisting in imputation of any of the commission of any of the private crimes against the private defendant party and act of lasciviousness. Okay. Before this, ang crimes that cannot be prosecuted the official, pero din, concubinage, adultery, starve. Pero ngayon, wala nang rape because rape is now a crime against person by virtue of Republic Act 8353. Sige? By the way, itong, you have to be very careful likewise. It's procedural, no? Yung concubinage and adultery. Ito, concubinage, adultery. Sabi, this, very specific. The rule is very specific. Concubinage and adultery cannot be prosecuted except on complaint of the offended spouse. Very clear, yan eh? Concubinage and adultery cannot be prosecuted except on complaint of the offended spouse. Okay, so, concubinage, sino ang offending spouse? Di ba the husband agree? Okay, the husband agrees the offending spouse. And therefore, who can prosecute concubinage? Only the wife. Ito, ang offending ito, the adulterous wife. And therefore, sino ang magpo-prosecute? The husband. Okay. I want you to be very careful with this because I've always mentioned this in my classes, no? Just to tell you the importance of being very, very careful with concubinage and adultery. Because there was one case when I was still FPC in Pasig. There was one case, no? Adultery was filed by the wife of the lover of the adulterous wife. Get me? Complaint for adultery was filed by the lover, who's married, the lover by the wife of the lover of the adulterous wife. But I'm personally knowledgeable of this because I was consulted on this. It was filed in the priest's office. It was filed, pero ang complaint is adultery. In other words, gigil yung wife doon sa adulterous wife. Yung kabit. Okay, so yun ang isa. Sabi natin siya, what do I do with this? Mga big time lawyers, so what? Kung big time, i-technical mo. Under the rules, it can only be prosecuted on complaint of the husband. She cannot sue for adultery because ang adultery is committed by the wife. The adulterous wife. Hindi naman siya ang wife ng wife, no? Okay, so sabi ko, i-technical mo, na-dismiss it on that ground. Why don't you ask the husband to file the adultery complaint? Sabi niya, ayaw ng husband, TL niya masyado yung wife niya. True love. So, it was dismissed. It was never revived. Yung pag-alis na. Ayan. Okay. Now, next point to discuss, please, and it's very important. Sabi dito, in section 8 of Rule 110, I hope you have your rules now with you, because I'm pointing out yung important, no? Yung amendment. In section 8, sabi, the complainer information shall state the destination of the theft and shall state the qualifying and aggravating circumstances. That's very important now, no? You have to state the qualifying and aggravating circumstances. These circumstances must be both alleged and proved for purposes of conviction, correct? It must be both alleged and proved. Now, the qualifying, aggravating, and aggravating circumstances. What is the purpose now? What is the rationale for requiring that both that the qualifying and aggravating circumstances would have to be alleged in the information? This is how to apprise the accused of what circumstances may be taken against him in the event of any judgment of conviction that may be rendered, because it would affect the imposable penalty. Yan ang rationale dyan. And of course, so by virtue of this, the aggravating circumstances must be both alleged and proved. Okay. Now, let me just call your attention. This is actually not an amended rule. No? In rule of section 13, duplicity. Let me just call your attention to this. No? What do you mean by duplicity? When you say duplicity, the rule is one information must charge only one offense. You know this is basic. I just call your attention to the importance of this provision. One information must charge only one offense. If the information charges more than one offense, that information is duplicitous. Ergo, it is vulnerable to a coercion. That is the rule. One information must charge only one offense. If the information charges more than one offense, that information is duplicitous. Ergo, it is vulnerable to a coercion. Diba, motion to quash, one of the grounds for motion to quash is duplicity of the offense. Okay. You know very well, if the motion to quash is founded on duplicity, it has to be seasonably invoked, otherwise waived. That is the rule. You know, you motion to quash, motion to quash would have to be seasonably invoked. Seasonably filed on any of the grounds provided for under the rules. Otherwise, the grounds are waived. The grounds are waived. Except, your motion to quash, the grounds are waived. Except, lack of jurisdiction over the offense charge, no offense charge, or the facts charged in the facts charged do not constitute an offense. But yes, criminal liability is extinguished. And number 4, DJ. Double jeopardy, not disc jockey. So there are 4 exceptions to the waiver. If you do not seasonably invoke the grounds for a motion to quash, waive. Except no offense charge, or the facts charged in the information do not constitute an offense, lack of jurisdiction over the offense charge, criminal liability has been extinguished, and DJ, double jeopardy. Meaning that ito, kahit hindi mo ni-raise, when is it seasonably raised? When are these grounds for a motion to quash seasonably raised? Before arraignment. Any of these 4 grounds, itong exceptions, you may raise them at any time, even after arraignment. Okay, now, going back to duplicity. Duplicity is not one of the 4. Ergo, waivable yan. For as long as you do not seasonably invoke it, you do not timely invoke it, waive. Okay. Now, if the information, therefore, if the information is duplicitous, meaning it charges more than one offense, you do not seasonably raise an objection to the duplicitous character, waive ang objection mo to the duplicitous character of the information. Well done. If waive ang objection mo and the information is duplicitous, can you be convicted of as many offenses as are charged and proved? Kasi waived it. You can object. And therefore, you can be convicted. Kahit na, even if it's duplicitous, but you are given an opportunity to object to the duplicitous character. You did not seasonably raise your objection against the duplicitous character of the information, waive, and therefore, under the rules, you can be convicted of as many offenses as are charged and proved. Next point. Sabi natin, one information must charge only one offense. If the information charges more than one offense, duplicitous. Except in cases of complex crime. Diba? What in case of complex crime? Yun ang exception na. Except when the law prescribes a single punishment for various offenses. Yan ang complex crime. In the complex crime, one act producing 2 or more grave or less grave felonies, one crime is a necessary means to commit another crime, so 2 or more crimes yan. And therefore, but there's only one penalty. The penalty for the most serious to be imposed in is maximum. Article 48 of the revised penal code. So that is an exception. Only a complex crime can be an exception to duplicity. But if it's not a complex crime and the information charges more than one offense, before arraignment, invoke, 5, emotion to quash. Okay, now, importante, there is an amendment. In Section 14, you speak about substitution, you speak about amendment. Take note that yung amendment is first paragraph and second paragraph. Substitution is third paragraph. Simple lang yan. Where do you draw the distinction between amendment and substitution? Amendment, di ba, amendment, then likewise involves a change in the information. Substitution, it likewise involves a change of information. It is when the second information charges the same offense as in the first information, or an offense which is necessarily included in, or it necessarily includes the offense charged in the first information, only amendment is necessary. But if the second information charges an offense totally different, totally distinct from the information charged in the first, from the offense charged in the first information, there is substitution. One information being replaced by another. Again, yun ang telling point dyan eh. For you to remember, difference between amendment and substitution. If the second information, the amended information, charges an offense, which is the same as the first offense charged in the first information, or which is necessarily included in, or necessarily includes the offense charged in the first information, only amendment is necessary. But if the second information charges a totally different, totally distinct offense than the offense charged in the first information, substitution. Okay, the rule in amendment is, before arraignment, the information may be amended in substance and in form before arraignment, even without prior leave of court. Correct? Okay. After arraignment, the information can be amended only with prior leave of court, and for as long as it will not prejudice the substantial rights of the accused. Correct? Ano yung bago? Even before arraignment, there is need for leave of court. Kasi dapat na, pagka before arraignment, no need for leave of court. It can be amended, generally, in substance and in form. Now, what is the new provision? Even before arraignment, kailangan there must be leave of court if the amendment consists in 1. Downgrading the offense charged, or 2. Excluding an accused from the offense charged. General rule, amendment in substance and in form before arraignment without leave of court. After arraignment, amendment only in form, not in substance, but with prior leave of court, and for as long as it will not prejudice the substantial rights of the accused. Bago, even before arraignment, you need prior leave of court to amend if the amendment consists in either downgrading, nibaba, the offense charge, or excluding an accused from the offense charge. For example, originally charged with murder, ibinaba after an investigation, a reinvestigation, ibinaba to homicide. That is an amendment, but even before arraignment, you have to obtain prior leave of court and with notice to the private offended party. Okay, now, when you go to substitution, I said, in substitution, if the second information charges an offense that is totally distinct and different from the offense charged in the first information. Okay, dito, I want you to remember this, if it appears at any time before judgment that a mistake has been made in charging the proper offense, the court shall dismiss the original complaint or information upon the filing of a new one charging the proper offense in accordance with Rule 119, provided the accused is not placed in double jeopardy. I want you to underline upon. Upon the filing of a new one. Do not ignore this upon. Because it if a mistake has been made in the course of the trial, it is determined that the mistake has been made in charging the proper offense. The court shall dismiss the original conveyed information upon the filing, which means that the court does not instantly dismiss. Kahit na the court determines na, mali ang charge. Mali ang charge. I cannot convict him of this charge because it was a wrong charge. Evidence does not speak for this charge, but for a different charge. So if the court determines that, the court does not immediately dismiss it. Kasi pag ni-dismiss niya, there's no more case. To ensure, therefore, continuity in the prosecution. Because the court is not saying that he's not guilty of anything. The court is simply saying that you are charging him with the wrong offense. The court does not say that the accused is not guilty. Kaya dapat i-dismiss. The rule is just saying that the court finds that a mistake is he can be held liable for this offense. Only that, hindi naka-charge it. You cannot convict him for an offense which has not been charged. So if the court is simply saying that he is guilty of something of a different offense, but not of this offense with which he is charged before this court. So, kailangan upon. So the court does not dismiss. Bibigyan ang court ang prosecutor the opportunity to file a new information charging the proper offense in the light of the evidence so far submitted. So, kaliwaan yan. Pag-file, dismiss. Hindi kasi yung dismiss, tsaka file. Follow? Very important yung upon. To ensure the continuity of the prosecution. Okay. Venue, you know this, venue in criminal cases jurisdictional meaning. What court is jurisdiction? It is the court of the place where the offense is committed or where any of the essential ingredients of the crime took place. In cases of what? In cases of continuing crimes. Yeah? In case of continuing crimes. Okay, so jurisdiction in criminal cases is vested in the court of the place where the crime was committed or where any of the essential ingredients of the offense took place. In cases of a continuing crime. Intervention of the defendant party in criminal action, that would refer to what? Participation of a private prosecutor. Remember, the private prosecutor he always acts under the direction and control of the public prosecutor. As in fact, if there's no public prosecutor available, before he's allowed to enter his appearance, or he's allowed to prosecute the private prosecutor, he has to obtain a written authority. He has to obtain a written authority from the provincial and city prosecutor. But always, the private prosecutor acts and prosecutes the case under the direct control and supervision of the public prosecutor. On paper lang yan, sa totoong buhay. If there is a private prosecutor, that gives the fiscal the opportunity to rest. And entering your this private prosecutor subject to the direct control and supervision of the public prosecutor. Fiscal, any authority? Sabi, I'm allowing the private prosecutor, Your Honor, to present evidence for the prosecution subject to my control and supervision. Bunyang tutulong na yan. Sometimes it happens. Okay, so yung private prosecutor cannot participate, particularly in handling the criminal aspect without authority from the public prosecutor. Okay, now, we're talking about, sabi nga na the offended party can enter into the picture for purposes of the civil aspect of the case via the entry of appearance of a private prosecutor. Okay, now, so we're talking about civil liability. Now, let's go to Rule 111. Importante, let me stress, very important. Yung amendment dito, Section 1. All telling ito When the criminal action is instituted, the civil action for the recovery of liability arising from the offense charged shall be deemed instituted with the criminal action unless the private offended party waives the civil action, reserves the right to institute a separate civil action, or institutes the civil action prior to the criminal action. Okay. Dati-dati, the nexus has been removed. Meaning that this implied institution, the rule is, once a criminal action is instituted, the civil action is impliedly instituted with the criminal action. Walang qualification, take note. Once a criminal action is instituted, the civil action is impliedly instituted with the criminal action. Ngayon, very clear. What is impliedly instituted with the criminal action is only that civil action flowing from the crime subject of the criminal action. What is impliedly instituted or deemed instituted with the criminal action is only that civil action flowing from the crime subject of the criminal action. If the civil action, in other words, if the civil action does not flow from the crime subject of the criminal action, walang implied institution. Now, so yun it is only the civil action. What is implied instituted is only that civil action flowing from the crime subject of the criminal action. Now, ano yung exceptions? If there has been a waiver of the right to institute a separate civil action, the waiver of the civil action, or number two, if the offended party reserved the right to institute a separate civil action or prior institution. What does this mean? The civil action, as I said, an illustration ng the drawing, the civil action that is impliedly instituted with the criminal action is only and should only be that civil action flowing from the crime subject of the criminal action. Yan na, clear na yan. Except waiver, reservation, prior institution. Diba? Andiyan sa exempt? What do these exceptions mean? The exceptions simply mean that there is no implied institution of a civil action with the criminal action if it has been waived. Natural, we leave it. So walang implied institution. Or there has been a reservation to institute a separate civil action. Or the civil action has already been instituted ahead of the criminal action. That is what is meant by exception. These are exceptions only to the implied institution. But the civil action that is waived, the civil action that is reserved, the civil action that has been instituted ahead of the criminal action is only that civil action flowing from the crime subject of the criminal action. Kala niya? Uy. Is it clear? Do not kasi yung iba sinasabi nila, exceptions meaning, walang hindi kino-qualify. Because the rule is now kino-qualify na. Kailangan, you talk about implied institution only with respect to civil action flowing from the crime subject of the criminal action. Ito rin, waived, reserved, prior institution, you speak of civil actions, but not any civil action, only that civil action flowing from the crime subject of the criminal action. Clear? Okay, that is why, let me just go to, tingnan nyo to, yung Section 4 of Rule 111, this incorporates the doctrine laid down in the case of People versus Bayotas. Remember? Yung case of People versus Bayotas, it is 1994 case. Yung si Mamang Bayotas, he was convicted of rape. Have you read this? Si Mamang Bayotas, he was convicted of rape. Tapos he appealed. He appealed the judgment conviction. During the pendency of the appeal, before the RTC, before the CA, he died. The rule, what was the effect of his death during the pendency of this appeal? Because you know very well, under the rules, if a person dies, or the convict dies before final judgment, if the convict dies before final judgment, both his criminal as well as his civil liabilities are extinguished. Okay. In this case, si Mamang Bayotas, he died during the pendency of his appeal. Question, what was the effect of his death during the pendency of his appeal? His criminal liability is extinguished. His criminal liability is extinguished. Okay. Next question. Was his civil liability likewise extinguished? Bakit sinasabi natin his criminal liability was extinguished? Because he died during the pendency of his appeal. Meaning, he died before final judgment. A judgment that has been brought up on appeal can never acquire finality until after the resolution of the appeal. Correct? So, when he died during the pendency of his appeal before the CA, no question. No final judgment as yet. When he died, therefore, his criminal liability has been extinguished. What about his civil liability? Take note, kinwalify na naman na yun. Not every civil liability can be extinguished if he died before final judgment. Under the Bayotas ruling, which is now incorporated here in the present rules, it is only that civil liability flowing from the crime of which he was convicted that is likewise extinguished. Meaning that if his civil liability proceeds or flows from other sources other than the crime of which he was convicted, pwede pa i-continue ang prosecution. It is not extinguished. Even if he died before final judgment. Because that civil liability flows from other sources other than the crime of which he was convicted. If the civil liability flowed from the crime of which he was convicted, and he died before final judgment, no question, extinguished. But if it is flowed from other sources of it will be allowed to continue. Against the estate or legal representative after substitution. In which case, you talk about substitution already, civil liability na natin ang prosecute dyan, because the criminal liability has already been extinguished. So if it's a civil liability, pasok na rules on civil procedure. Diba? The effect of death, if the defendant dies before entry or final judgment. Pala? Bago. Okay, now, let's go back to Section 1 of Rule 111. Kasi very important yan, implied institution. Okay? Now, reservation. Now, please take note ito. No filing fee shall be required for actual damages. Ito. No counterclaim, cross-claim, or third-party complaint may be filed by the accused in the criminal case. No counterclaim, cross-claim, or third party. It is the defendant in civil cases who files that. Counterclaim, cross-claim, and third-party complaint. Now, in criminal cases, no counterclaim, cross-claim, or third-party complaint may be filed with the accused in the criminal case, but any cause of action which would have been the subject thereof may be litigated in a separate civil action. Take note that the civil liability that we're talking about that can be implied instituted is a civil liability that is attributed to the accused. Liability na nga, civil liability. Ito, you talk about counterclaim, you talk about cross-claim, you talk about third-party complaint. It is the accused of the includes liability against the offended party or against a third person. Correct? Hindi pwede yan. So very clear. This effectively abandoned the ruling in the case of Caballero versus Santos. Kasi one case lang yan where the counterclaim was allowed. I think it was a third-party complaint that was allowed. Remember, in a criminal case, it is the accused who is supposed to be guilty. Bakit mo siya bibigyan ng chance na itapon sa private defendant party? No, you cannot. If you have a cause of action, prosecute it in a separate civil action. But you cannot prosecute it in that case where you yourself are the accuser. Okay, now, ito pa. Ito. Criminal action, take note of this, Criminal action for violation of BP 22, the bouncing check law. Bouncing checks law. Criminal action for resumes and just bouncing check law. Bouncing check law. The criminal action for violation of BP 22 shall be deemed to include the corresponding civil action. No reservation to file a separate civil action. Diba? No reservation to file such civil action separately shall be allowed. Upon the filing of the joint and civil criminal action, the offending party shall pay in full the filing fees based on the amount of the check involved, which shall be considered as actual damages made. Okay? If the check, the BP 22 falls under the original exclusive jurisdiction of the MTCs. BP 22 falls under the original exclusive jurisdiction of the MTCs. The value of the check is in the amount of 1 million pesos. The check is in the amount of 1 million pesos. Prosecution for violation of BP 22. Filed before the MTC. Accused, no separate civil action is allowed. Accused now is found guilty. A judgment of conviction is rendered against the accused. In the amount and ordinary, no separate civil action is allowed. Question: can the court MTC award civil liability in the amount of 1 million pesos, which is over and above its jurisdictional limit? Diba MTC and EPC now is 400,000, MTC is 300,000. Can the court MTC award damages in the amount of 1 million pesos, which is based on the value of the check? Yes. No separate civil action is allowed. Now if you would want to ask for some more damages, doon ka mag-separate. But not with respect to value. So, no separate civil action is allowed. Implied the institute na dyan. And therefore, the MTC can award. Okay. Isa pa. Ito is an old rule, no? Yung extinction of the penal does not carry with it extinction of the civil action. However, where the civil action based on the derelict should be deemed extinguished, if there's a finding in the final judgment in criminal action that the act or omission from which a civil liability may arise did not exist. Okay, nirephrase lang po yan. Because the rule formally is the extinction of the penal does not carry with it extinction of the civil unless there's a declaration in the final judgment that the fact from which the civil might arise did not exist. For example, sabihin lang sa judgment, he's acquitted because there is no crime that he committed. Hindi ba the civil liability proceeds from the crime? The civil liability proceeds from the crime. Now, if the court in the judgment says, he's acquitted because there is no crime. There's no crime from which the civil liability might proceed, and therefore extinguished. It is not a definite, the rules do not require a definite declaration. No criminal, no civil. No. You can deduce it from the words used in the judgment. For example, if he's acquitted, case is dismissed because no crime was committed, his court is accordingly acquitted, and therefore, because there's no crime, since there's no crime, walang source for civil liability, extinguish din yung civil liability. But, if he's, let's say, acquitted on the ground of reasonable doubt, is the extinction, acquitted siya, so extinguish yung criminal liability, correct? Now, extinction of the penal does not carry with it extinction of the civil. Ito example, if he extinguished ang criminal because of reasonable doubt, take note, reasonable doubt on his criminal liability. But it does not mean, that no crime was committed. Only that there is doubt that he did it. There is doubt on his criminal liability. Siya kaya, There is doubt that he did the crime. But there is no definitive finding that no crime was committed. Ergo, can there be civil liability? Yes. Okay. Now, let's go to a very important concept likewise. Prejudicial question. Okay. As far as prejudicial question is concerned, if you notice, yung elements, go to section 7, no? The last section. The elements of a prejudicial question are, first, previously instituted civil action. Number, which involved an issue similar or intimately related to the issue raised in the subsequent criminal action. And number 2, the resolution of such issue determines whether or not the criminal action may proceed. In other words, before ito, in-amend lang yung words, ang determining factor is will this action, or is this action, civil action, determinative of the guilt or innocence of the accused in the criminal action? Is this because the rule is, tingnan niya, the rule is, there is always preference in the prosecution of a criminal action. In other words, if there is a preference in the prosecution of criminal action with respect to civil actions flowing from the crime subject of the criminal action. Okay, now, if let's say criminal action is instituted, the separate civil action that was reserved based on the crime subject of the criminal action, hindi muna yan ipaprosecute until after the termination of the resolution of the criminal action. Now, if on the other hand, the civil action flowing from the crime that would be the subject of a criminal action is instituted ahead of the criminal action, na-institute siya during the pendency of the civil action, na-file ang criminal action, di ba suspended ang civil action in whatever stage it may be found until after the resolution of the criminal action. That is what I call preference in the prosecution of a criminal action. Exemption itong prejudicial question. Why? Because the prejudicial question speaks of the civil action that must first be resolved before the criminal action can proceed. Why? Because the civil action will now be determinative of the guilt or innocence of the accused in the criminal action. It will lay the basis for determining whether or not the criminal case can and will proceed. So, exemption nga to the rule on preference in the prosecution of a criminal action. Follow nyo? Children? Okay. Now, let me just illustrate. Ito illustration lang ito, with respect to a prejudicial question. Paano lang natin yung yun. This was actually made an illustration by Justice Aguilera. It's very clear illustration, I think, of a prejudicial question, no? Tayo dito. Ano ba? A marries B. A marries B. Subsequently, A marries C. But A claims that he was forced to marry C. A marries B. Subsequently, A marries C. But he claimed that he was forced, shotgun, to marry C. Okay. Since he claims that he was forced to marry C, A now files an action to annul. Tama ba yun? annul his marriage to C. So action for annulment. Because he claims that he was forced to marry C. So he filed an action to annul his marriage to C. Okay, now, B learns that A married C. B learns that A married C. So B now files an action for Biden versus A. B files an action for Biden versus A. Illustration. Okay. First element. Civil action. Previously instituted civil action. This is the criminal action. This is the civil action. Correct? Action to annul the civil action. Bigamy is the criminal action. The civil action. Previously instituted civil action. Meaning, the civil action is instituted ahead of the criminal action. Correct? Hindi ba pasok na sa first element? The civil action was instituted ahead of the criminal action. Okay. Next element. The civil action will determine whether or not the criminal action can proceed. In other words, the civil action will be determinative of the guilt or innocence of the accused in the criminal action. Okay. So, next element. If the action, so ito uunahin, di ba? Okay. If the action to annul is dismissed. If the action to annul is dismissed, therefore, he has 2 marriages. Existing marriages. Because dismissed it, yung action to annul. Okay. If the action to annul is dismissed, he has 2 existing marriages. And therefore, can he be convicted of bigamy? If, on the other hand, the action to annul is granted, meaning the second marriage is annulled. He has only 1 existing marriage. Can he be convicted of bigamy? No, because bigamy involves 2 existing marriages. Therefore, is the civil action determinative of the guilt or innocence of the accused in the criminal action? And therefore, it is a prejudicial question. You clear? I'll take a break. Papakiramdaman ko lang.
Thank you.